We will hear argument this morning in Case 24-813, Chevron versus Plaquemines Parish. Mr. Clement.
Mr. Chief Justice, and may it please the Court, Congress amended the Federal Officer Removal Act in 2011 and added the words "related to." Both before and after that amendment, this Court emphasized those are words of substantial breadth, meaning connected to or associated with. Thus, the import of Congress adding those capacious words to the statute is hard to deny. So much so that respondents effectively spend very little time defending the lower court's reasoning on "related to." Instead, they shift their focus to "acting under," which is a distinct requirement of the statute addressing who can remove and an issue on which they lost unanimously below. That effort to change the subject does not work. The classic person who acts under a government official is a government contractor providing the government with what it needs to win a war. Thus, no one doubts that the refining of avgas under federal contract satisfies the acting under condition. The only question is whether that refining activity under contract is connected to or associated with the production activities assailed in these lawsuits. The answer to that question is straightforward. The petitioners here produced the very kinds of crude that were the indispensable component of the avgas they refined under federal contract, and the contracts themselves drew the connection between avgas and crude by pegging the price that the government paid for refined avgas to the price of crude, and the government promising that it would rebate any new taxes on crude. What is more, if the petitioner's production of crude had been enjoined by a state court during World War II, the federal government's efforts, the war efforts, would have suffered. Now, respondents think that it's anomalous to allow only the vertically integrated producers to remove to federal court. I don't think there's anything odd about allowing people in direct privity with the federal government to remove, but any anomaly can be alleviated by leveling up and allowing everyone who produced crude under the direct supervision of the federal government under the unique circumstances of World War II to remove, as the Solicitor General suggests. Either way, this court belongs in federal court. I welcome the court's questions.
Mr. Clement, how would your argument differ if this were pre-2011?
So I think my argument would be a lot tougher pre-2011, because obviously before 2011, the statute would have said "for," not "for or related to." Now, I might have given it the college try, and even under "for," and of course, if you get to the Solicitor General's or our alternative argument, I think then we could satisfy the statute even pre-2011. But that would require, as we think is correct, understanding that this isn't ordinary regulation of the type that was at issue at Watson. This was close supervision of what effectively amounted to a joint venture during World War II to get as much oil out of the ground, transported to the refineries that the government was helping to finance to expand, all in an effort to get petroleum products, and in particular avgas, onto the war front. So I think we could have won under that theory even pre-2011, but I do think the statute—
But you do admit that this is quite a dramatic change to the removal statute.
I would say it's a substantial expansion of the statute, but of course it's a substantial expansion that I think follows directly from the words that Congress added to the statute. And that's why I think it's really relevant that the plain meaning, the dictionary definitions of "related to," always had a broad meaning, and of course this court, in cases like Morales, had said this is a very broad term, and Congress added it anyways. And so I think we should take Congress at its word in the text of the statute.